What it's actually addressed to is not starting with free speech and the law as a general issue and general problem, but with the Conservative government's proposals for legislation for freedom of speech and academic freedom in institutions of higher education. My starting point, but basically what I have to say about this is, well, I start with the point that it happens that it comes along, this stuff comes along more or less exactly contemporaneously with Conservative Party no platforming campaign against Ken Loach at the institution of higher education where I happen to work. So that the idea that we should believe that the Conservative Party is about suppressing no platforming and making freedom of academic speech, freedom of speech and freedom of academic speech and endeavours is a pretty bleeding implausible one. And the question in a sense is, what are they doing here? And then there's a larger question which is posed by the what are they doing here? And I may have things to say about freedom of speech and the law more generally, but actually I'm mainly going to be talking just about this latest initiative. And the essence of what I have to say about this latest initiative is that, like the overwhelming majority of pieces of legislation proposed in the 2021 Queen's Speech, this is a piece of sham legislation whose purpose is merely to get favourable headlines in the Daily Mail without making any significant difference to what happens in the real world. And I'm going to say a limited amount about that, and then I will probably say a little bit more. In practice, it's inevitable that this should be the case, even if there had been a serious and honest intention of increasing freedom of speech in universities and institutions of higher education. It would be inconsistent for them to actually have that serious and honest intention while still running a campaign in favour of no platforming people like Ken Loach and campaigning against, quote, anti-Semitism, demanding that universities adopt the quote, International Holocaust Remembrance Association definition of anti-Semitism, unquote, and so on, which is entirely from beginning to end a no platforming project on the basis of political correctness, the political correctness in this case being that anti-Zionism is allegedly racism, and that because this is allegedly racism, therefore it ought to be no platformed, and so on and so forth. So what then are the concrete proposals which government is making in relation to this stuff? And the background context is that it's already the case by virtue of Section 43 of the Education Number 2 Act 1986, that universities, institutions of higher education are under a statutory duty to secure and promote freedom of speech on campus. In fact, it was a mildly fun circumstance that when the St Hugh's College JCR proposed to the college governing body that we ought to associate ourselves with the campaign to no platform Ken Loach, it was possible for me to say, I'm sorry, colleagues, that this is illegal under the Education Number 2 Act 1986, Section 43. And this particular campaign, as it happened, this particular campaign was seen off. It was seen off because the St Peter's College authorities were tough-minded enough to see it off and say, sorry, sunshine, that's not us. There's a very similar campaign going on from out of the conservative media, again addressed to Oxford. We've had Magdalen College Middle Common Room took down their photograph of the Queen on the basis that she's associated with the graduate. This is the graduate students, on the basis that she's associated with recent British colonialism, which is of course true. And the president of Magdalen again sensibly said to the press, who were making an enormous fuss about this, no, this is the MCR's business. This is got nothing to do with the college. We don't have a view one way or the other about whether how the middle common room, the graduate common room should be decorated. It's up to them what they want to do. The third one, which is more substantive, has been going on at the moment. It is again an Oxford story. Rhodes must fall. There is a statue of Cecil Rhodes on the north end of Oriole College, 2 floors up, hidden behind netting, which is there to stop birds shitting on it, as was the case previously. And there has been a campaign for some years, Rhodes Must Fall campaign, which has been demanding the removal of this statue of Cecil Rhodes as the famous colonialist and pirate raider who is the originator of Rhodesia, what became Zimbabwe. So he's it's one of the things, again, curious about this, that the target is Cecil Rhodes' statue on the top of halfway up Oriole College, difficult to see, and not Rhodes House, which is an institution entirely funded by Cecil Rhodes for scholarships for the students from the Commonwealth, which of course in Cecil Rhodes' time meant mainly students from the white Commonwealth. Rhodes House, however, clearly imagined that although the students campaigners have not got into their heads to campaign against Rhodes House, that there's a danger that they may do so, and they've got building work going on, and their hoardings covering the building work are entirely diversity oriented, trying to show how the Rhodes Trust, whatever the hell Cecil Rhodes' history may be, the Rhodes Trust is eminently advocates of diversity and of opposition to racial discrimination and so on and so forth. The conservative press at the moment has been campaigning because Oriole College. Oriole College is the most traditionalist of the Oxford colleges, and it was, I think, the last men's college to admit women. When I was a student in the 1970s, there was an organization called the Oriole Reactionary Caucus, which went round Oxford chalking up the SS symbol on various buildings around the city. It was Oriolites who were partly involved in the notorious incident of the Monday Club, which was a right-wing caucus in the Conservative Party. The Oxford University Monday Club at their annual dinner marched around one of the colleges singing the Horst Wessel Lied, as a result of which they were excluded from the use of the college for their annual dinners in the future. So Oriole, in that sense, targeting Oriole is not a stupid thing to do, because it is the most right-wing, traditionally the most right-wing of the colleges. So Oriole has been havering and wavering about whether to take down Rhodes' statue. And 150 academics have signed an open letter saying that they won't give tutorials to Oriole students. This is, again, under the peculiar regime which prevails in Oxford. There is no breach of contract or illegality involved in this, because everybody is contracted to supply tutorials to members of their own college, and the only people who are obliged to teach Oriole students are Oriole tutors. So that this is no different from this is not a in secondary industrial action or industrial action of any sort. It's merely refusing to contract, saying that you're not prepared to contract with somebody who would otherwise be asking you for a contract which would be completely voluntary, whether to enter into it or not. Nonetheless, this has become, indeed, Ben Kosing comments, freedom of contract. It's a freedom of contract principle. Nonetheless, this has become a cause célèbre in the conservative press, a terrible, terrible attack on academic principle by refusing to teach students from Oriole. So this is going in this narrative. In essence, what's happening is Conservative Party election campaigning, Conservative Party campaigning for the next general election around trying to adopt the American policy of culture wars, trying to spin the American policy of culture wars. It is also the case that the Conservative Party wants to reverse the Blair era expansion of higher education, and possibly also reverse some of the earlier, the Thatcher era expansion of higher education, and send more school kids to quote apprenticeship, unquote, training schemes, etc. And so we also have quite a lot of right-wing press at the moment about universities are a waste of money and a waste of time, and the students would do better to get jobs and so on, if they could get jobs. In reality, what's been done with the expansion of higher education is to a large extent to mask the statistics for youth unemployment by sending more people to courses of one sort and another. However, what is the government proposing to do? We have to start with the background position as far as the law is concerned. As I said, the Section 43 of the Education Number 28, 1986 imposes a legal duty on universities to protect and promote freedom of speech in universities and other institutions of higher education. The government proposes to tighten up, though they don't tell us how they're going to tighten up this duty. Yeah. Secondly, that there will be a new director of free speech within the Office for Students regulatory body. Now, the Office for Students technically already requires universities to lay out how they're going to comply with Section 43 of the Education Number 2 Act 1986 as a condition of their being entitled to give degrees out. But all that means is you have to submit forms and tick boxes to show that you've got a pro-free speech policy. The new director of free speech within the Office for Students will be a person who is responsible for promoting this regulatory framework, and further is responsible for hearing and dealing with complaints from students about and others about violation of the Section 43 duty. Yeah. The OFS is intended to be given an increased power to sanction universities which are not compliant with its free speech instructions, but given that it already has the power to take away the degree awarding powers if there's non-compliance with Section 43. It's not clear that that's going to make any difference. I guess it's going to be that this guy will be, and I'm no doubt he will be, headlined as the free speech czar, which of course is a nice contradiction in terms, but like the anti-drugs czar and all of the other czars of one sort and another who have been created. They have called him the free speech champion, or alternatively the director of free speech. I guess being aware that free speech czar sounds a bit weird. Secondly, there will be tightened regulation of what is acceptable, i.e. that there has to be a whole load of text which is put in as compulsory in university free speech policies. The present position is the universities are required to tell students about their free speech policies every year. They don't propose to change that. And I don't think that they propose to insist on us having student assemblies at which the Vice-Chancellor will stand up and read out the government's favoured text about free speech policy. Thirdly, student unions will be directly regulated by OFS, the Direct Office for Students. The present position is that student unions have this rather ambiguous character, that they are, in theory, charities, and as such are, in theory, regulated by the Charity Commission. And it used to be a fun activity for right-wing law students in the 1970s to judicial review student unions which tried to pass anti-apartheid legislation on the ground that this was anti-apartheid resolutions, or on the ground this was political activity which student unions aren't allowed to do because they're charities. There's a sort of curious balance between, on the one hand, this proposition, and on the other hand, the proposition which is generally been part of the culture of higher education, that student unions are supposed to be autonomous bodies and not simply emanations of the university or of the state, and in consequence are also supposed to be institutions through which students learn how to do politics, albeit the politics which they learn how to do is very much that of the Labour bureaucracy. Ben's also made the point they're not financially autonomous. That's a sort of ambiguity, because they're, I'm not sure what the present position is, but certainly as of the 1970s, it was the case that student unions were paid for by subscriptions paid by students, but these subscriptions paid by students were and are compulsory. You don't get to opt out of paying your student union subscription. Oxford was odd again in this one in the 70s, in that the central representative body, the Student Representative Council, was voluntary. It was the college JCRs, which are the student unions for the individual colleges, which are compulsory, and they chose whether or not to participate in SRC, which is now called Oxford University Student Union. However, so bringing student unions under the remit of the Office for Students, as opposed to the Charity Commission, is supposed, according to the government's consultation paper, to produce a more hands-on regulatory operation through this free speech czar. And I'm going to keep on calling him free speech czar, in spite of the fact that's not what they call him, because through the free speech czar intervening when complaints are made against student unions that they've promoted anti-free speech operations of one sort and another. Fourthly and finally, there is going to be a new tort liability against universities for violation of Section 43 of the Education No. 2 Act 1980, violation of the free speech duty, which will lie in favour of people who claim to have suffered loss as a result of cancellation campaigns, people who have personally been cancelled as a result of cancellation campaigns, the organisers of meetings who have been cancelled and have then had to pay money for rooms which they've booked and have lost that money because it's been cancelled. The background to this is that the court said that there isn't such a liability. This is part of a much more general phenomenon of the courts trying to limit the scope of civil liabilities for breach of statutory duties. And because there isn't such a liability, it's also the case that there's no damages to be awarded in judicial review proceedings. And further, that there are serious limitations on who has standing to sue in judicial review proceedings. That is where you go to the court and say, court, please quash this decision which has been made by this public body or institution or whatever, because it's contrary to law. Who has the right to claim on that basis? So creating a new tort liability is supposed to be beneficial from this point of view of deterring anti-free speech operations. Exactly who? Ben, you raised a question of that affects academics teaching. I think not. It affects, as defined, it affects it's the university if the university violates free speech rights. Yeah. Freedom of speech, however, and this is all through this. This is February. They haven't changed the current proposals from this February 2021 consultation paper. All through this text, we are concerned with, quote, freedom of speech within the law, unquote. Freedom of speech within the law. Of course, there is freedom of speech which is outside the law. Speech which is within the law, speech which is outside the law. What speech is outside the law? In fact, the consultation paper discusses two areas in which speech may be said to be outside the law and equivocates on both of them. The first is the Equality Act 2010, and the public sector equality duty, which arises under the Equality Act 2010. Now, in point of fact, actually, it's the Equality Act 2010 and the public sector equality duty arising under the Equality Act 2010, which is the principal ground which has been given for no platforming. The argument is that anti-Zionist speech is anti-Semitic, and because anti-Zionist speech is anti-Semitic, it in consequence means that Jewish students are made unsafe. And because Jewish students are made unsafe, permitting anti-Zionist speech is harassment. But then equally, permitting TERF speech, trans-exclusionary radical feminist speech, is harassment of trans men and women. Permitting the use of overt racist arguments is harassment of black students. But equally, actually, it could be the case that permitting black supremacist argument, and of course, when this stuff started in the Race Relations Act, 1967, Michael X, the first person convicted of under the Race Relations Act, was a Black Power advocate, not a far rightist. So the appendix in the consultation paper weasels over this question and says, in our view, In our view, 68, sorry, yeah, it's the Act of 68 which creates the new. Anyhow, in our view, it is only harassment under the Act if it's targeted on a particular individual. Well, that would be plausible if it weren't for the fact that the harassment offence under the 2010 Act is unwanted conduct related to a relevant protected characteristic, and the conduct has the purpose or effect of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for that person. So that the argument that there is a large space of offensive speech which is offensive to people but is not illegalized by the provisions of the Equality Act 2010 is bollocks. It's not true. The reality is that the Equality Act, the harassment section under the Equality Act 2010 is defined excessively broadly. It's defined excessively broadly because the courts took an excessively narrow approach to the preceding definitions of harassment, which were intended for stuff which was targeted, and refused to say, look, we can have evidence that this guy has been going around carrying on a Nazi agitation, and therefore we can reasonably infer that when he says nigger, that he's actually saying nigger with a view to harassing people. Having taken the view that that stuff is not admissible evidence, that they can't run the prosecution in that way, then Parliament, under the late period of the Brown administration, and then it's passed by the Cameron administration, drafts the harassment clause so broadly that it's actually inconsistent with any general freedom of political speech. Secondly, and probably equally important, in fact, is the prevent duty, sections 26 to 35 of the Counter-Terrorism and Security Act 2015. General duty on I'm not going to be more detailed on that, it would take too long. General duty on the public institutions of one sort and another to have due regard to the need to prevent people from being drawn into terrorism, including higher education institutions. And the governing body, etc., must have regard to the guidance issued by the Secretary of State when carrying out the duty, and so on and so on and so on. Again, Oxford, we had a fairly extensive discussion about this stuff, and the original proposals which were brought forward by the administration to comply with the prevent duty fairly clearly would have shut down Islamic Society meetings, meetings which were hostile, anti-war meetings, etc., 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 as potentially involving drawing people into terrorism. Fortunately, colleagues in the law department pointed out that the 2015 Act does not impliedly repeal the 1986 Act, Section 43 of the 1986 Act, and certainly that the guidance issued by the Secretary of State in relation to the prevent duty does not impliedly repeal Section 43 of the 1986 Act, and therefore that there should not be compliance with the Secretary of State's guidance on the basis that compliance with the Secretary of State's guidance would be illegal under the terms of the 1986 Act. On the other hand, actually, that's Oxford, and I guess that an awful lot of other institutions that will just have complied with the Secretary of State's guidance rather than anything else. So this, back to our freedom of speech within the law, because we've got this very widely drawn prevent duty, we've got very widely drawn anti-terrorism legislation, we've got new widely drawn, very widely drawn equalities legislation on harassment. We've got we have actually also got very widely drawn anti-terrorism legislation, which is the Terrorism Act passed under Blair, criminalizes, for example, as terrorism, for example, hacking in the interests of Extinction Rebellion or for any other political purpose. We also got other stuff, which is illegal speech. Defamation, for example, is illegal speech. But what's defamation? Until Robert Maxwell fell off the back of a ship, saying that Robert Maxwell is a crook was defamation. And a whole raft of other examples of one sort and another, famously of the gagging injunctions adopted by various people to prevent speech. We've recently had the former British ambassador to Uzbekistan, who got sacked out of the administration for his failure to back up the friendly relationships between the British state and the torture government of Uzbekistan, jailed for contempt of court by revealing information which could be used to identify the witnesses in the sexual harassment case of Alex Salmond, in violation of the court's secrecy order. Having said that, the background to this is, in reality, it was impossible to, on bail, but charged and sentenced to jail on pending appeal. The background to this is that it was impossible to contest the validity of the evidence which had been given by these witnesses without revealing some degree of information which could be used to lead to the discovery of the names. So this is just an example of the range of things which are forms of speech which are contrary to law. So my point here is, when the government is saying we insist that the legislation must protect freedom of speech within the law, this expression within the law is very unambiguously weasel words, because without cutting down the scope of the harassment definition under the Equalities Act 2010, without getting rid of the prevent duty, without making clear that freedom of speech within the law means freedom of speech subject to the risk that you have. Obviously, there's a risk of being sued for defamation, but that risk of being sued for defamation is not a reason why the institution should shut down public meetings or say a risk of being sued, or a risk of being sued for contempt of court, or whatever the case may be. These are not reasons why institutions should shut down discussions. This issue is seriously problematic. Secondly, tort liability. Okay, how do we enforce a tort liability? in theory, if the tort liability is for a small amount of money, it can be brought in the small claims court but the adverse party in practice could always remove it, take it out by appeal. And certainly with cases like this, which are sort of potentially high profile, it's quite likely that they'll be shoved into the central courts, in spite of being relatively small amounts of money involved. And in a sense, actually, these are probably going to be treated as analogous to defamation, because certainly what we're really complaining of, suppose I was no platform by some institution which I was supposed to be going to speak at, and I wanted to litigate about it, what I would be really complaining about is not the loss of the price of a rail ticket or whatever it was it took me to get there, but the effect of the no platforming on my public reputation. So this is not defamation, but it's like defamation. And because it's not defamation, but it's like defamation, it will almost certainly wind up be taken over by the specialists in defamation. And the specialists in defamation are engaged in an activity which is best characterized by saying that the House of Windsor, House of Saxe-Coburg-Gotha / House of Windsor, has since the middle 19th century been selling and denying justice in violation of Magna Carta Chapter 29, which is still in force. One of the few bits of Magna Carta which is still in force is that the Crown promises that they will not sell and deny justice. Okay, you don't personally pay the Queen, as people used to personally pay King John for expedited treatment or to shut their opponent up in judicial proceedings. You can find the cases in the records because he sent letters to the judges saying, stop this case, the defendant has paid me to stop it. Queen Victoria, Edward VII, George V, George VI, Elizabeth II haven't personally been taking money for denying justice. They've been franchising it to the Bar of England and Wales and the Law Society through the free market in legal services, unquote. And in particular, in relation to defamation claims, the effect of these, the extortionate charges of barristers and solicitors concerned in dealing with defamation claims is both to price claimants, lower class claimants out of the market, and also to price lower class defendants out of the right to their day in court. Leave aside the point that the generally deep pockets wins. We know it hasn't been done in this country, it has been done in the States. It turns out that it's predictable who will win in public nuisance cases in connection with pollution, entirely predictable, not entirely predictable on the basis of who spends more. The other statistically significant factor is that Republican judges usually find for defendants in pollution cases. Democratic judges are more likely to find for claimants, but that's much less powerful impact than the impact of the amount spent on litigation. Deep pockets usually wins in litigation. So the sale and denial of justice, tort, it's not just libel cases where sale and denial of justice takes place. Hazel Genn's book Hard Bargaining, again back in the 1980s, demonstrated empirically that tort claimants in relation to industrial accidents and road traffic accidents usually wind up settling for much less than the law says they should get for their injuries, because the ability of the defendant insurance companies to exhaust the resources of the claimant's lawyers is so effective. Vince Cable's Wizard Wheeze choked off most industrial tribunal applications by hiking the fees up so that people couldn't afford it, to the point that finally the court struck it down as being an abuse of the power to set fees. But in immigration matters, the government has gone to the length of saying that nobody can appear for the immigration claimant in judicial review proceedings unless they've previously been approved by the Home Office. So, hey, in this case, the claimant is not allowed to have any lawyers other than those approved by the defendant. So my point, I guess, is in relation to this stuff, that the context of what they're doing with creating a tort liability, this is carefully designed that it will be under the control of this mechanism. It will be that a tort liability as such is necessarily controlled by this mechanism of the use of legal fees to choke off or facilitate access to justice. And we can see that, in fact, equally in relation to the Labour Party's disciplinary proceedings in the anti-Semitism campaigns, that the litigation brought by supporters of the witch hunt has been heard very rapidly, has been backed up with no doubt very substantial sums of money spent on litigation. The people who are penalised on the other hand, had much less access to this stuff. Okay, so then, but at the same time, take it to and fro in this stuff. It's not going to be the case. We saw off on the basis of, I say we, Oxford saw off on the basis of Section 43, the attempt to no platform Ken Loach at St. Peter's. But how many universities can and will be able to do that? I mean, again, actually, just in relation to potential expenditure on legal fees. Christchurch College, which is one of the richer colleges in the university, has been having trouble with its principal. I'm not going to say more than that. There's a fight going on between the academics on the one side and the principal on the other side. Who's right and who's wrong on this is who the hell knows. But the Charity Commission is intervening on the basis that the fellows have inappropriately spent money on litigating with the principal allegations made against the principal of personal misconduct. And that was a breach of trust as charity trustees. It's all too easy to imagine the Charity Commission intervening to say to St. Peter's College, if suppose that the Board of Deputies who got up the campaign against Ken Loach speaking at St. Peter's College had started litigation with St. Peter's, the Charity Commission would almost certainly have said it's your duty as charity trustees to roll over and comply with the demands rather than waste £30,000–40,000 on legal costs, which is the sort of money you'd be talking about at first instance without going to appeal. So designed, therefore, to be regulated in the interests of the Conservative Party and their friends. But it has to be said that they can have no legitimate, given that Section 43 of the Act has been in place since 1986, and it has never choked off student no platforming campaigns. There is absolutely no prospect of any really significant change in the practical operation of the legislation taking place. This is a set of rules which is going to increase the costs of the Office for Students, increase bureaucratic form filling operations affecting universities and colleges, and do so without making any significant impact on the frequency of no platforming campaigns. Indeed, actually, I can't remember if it's Peter Hitchens or Peter Oborne, the right-wing columnists in the Daily Mail. One of these two made the point that the result of this legislation will actually be almost certainly be to reduce free speech, because people will look over the bureaucrats will look over their shoulders and decline to take bookings at the first stage, which are in any way risky, because although if they cancel bookings, they'll be required to make a record of it. If they simply fail to accept a booking and say, sorry, we don't have any space, they will not be obliged to take a record of it. So likely it will in fact reduce freedom of academic speech, freedom of speech in universities, but not in the sort of direct way which one might, in a certain sense, one could imagine it operating in a very clearly discriminatory way, that anti-Zionist speech is taken to be illegal and racist speech is taken to be legal. It is perfectly possible, but it's more likely that it just does nothing. Like an awful lot of this legislation, you wind up, there's going to be more forms filled in, there's going to be more boxes ticked, there's going to be more paperwork of one sort and another, but actually no serious practical impact. This is the general situation. Chilling at most, yes, chilling, but actually, this is the general situation of an awful lot of legislation passed in recent years, that we get legislation which is designed to do the minimum possible while at the same time making good headlines for the Daily Mail. I've written on the criminal justice, the police crime, etc. bill, the policing bill, which there's been a kill the bill campaign about. But the reality is the kill the bill campaign, the only operative thing which it does, as far as I can see, other than wasting an awful lot of police time on making completely pointless reports of offences of violence, which the police would have to make in a different form anyhow. The only operative thing which it does is to abolish the public nuisance liability of polluters by requiring the offender to have intended or been reckless as to the actual effects of the public nuisance activity. Why is it doing that? It's doing that because the point of this bill and the point of the current bill is to simply to get good headlines. The same is true way back. Section 28 of the Local Government Act 1986, I think it was, prohibited local authorities from, quote, promoting homosexuality. The sole purpose of this bill, which had no practical teeth to it at all, was to serve as a continuation of the press campaign against the Inner London Education Authority and against teachers using the book Jenny Lives with Eric and Martin. Nothing, just simply headline for the purpose of the interplay with the headlines. I'm going to say I've spent almost all the time I was going to do simply on this bill, and I propose to say very little more indeed. So my one final point is this. This phenomenon of freedom of speech, bureaucratic regulation, interplay with press campaigning illustrates the fact, which is a point that has been made by Slavko Splichau, and which I have also made myself, I'll put it up in the chat in a minute when I've stopped talking, that freedom of the press and freedom of speech are counterposed ideas. How has it come to be the case that turf no platforming, say for example, this is either trans rights activists no platforming of turfs, or yeah, it is trans rights activists no platforming of turfs. We're almost entirely concerned with from that direction. Yeah. Trans rights activists campaigns of no platforming of turfs are minority, big time minority operations. In reality, actually, that's also true of pro-Zionist campaigns of no platforming of pro-Palestine activists. These are minority operations. Why do they impact on university bureaucracies? Why is notice taken of them? And the answer why notice is taken of them is because they're amplified. Who are they amplified by? They are amplified by the advertising-funded media in their own interests and in the interests of the Conservative Party, in the interests of their funders and in the interests of the Conservative Party. Freedom of the press is freedom of the concrete physical and business assets of corporate media institutions. Freedom of the press is not freedom of speech, it's freedom of amplified speech, freedom of the amplified speaker to drown out contrary points of view. And in fact, actually, quite a lot of these cases which give rise to the evidence which is being supported of there being a chilling atmosphere and so on and so forth, is entirely about the amplification of relatively small protest movements by the media and the responses of the image management guys in university corporate management of one sort and another. But this aspect of the story about free speech and universities and no platforming and so on and so forth, this aspect, this thing has nothing to say about it. Why? Because actually this process of amplification of minority points, small minority points of view by the advertising funded media, not in the interests of knowledge of the truth, not in the interests of the campaigners, but simply in the interests of government and Conservative Party news management. This freedom of speech in that sense, freedom of amplified speech is antagonistic to freedom of political speech more generally. So there's this ambiguity about freedom of speech versus freedom of the press, which I think, I'm not going to say we have a solution to this problem, but my personal view is that the solution to this problem is to prohibit the mixing of advertising with news or anything else, so that you can, they can advertise, they can put as many channels with nothing but advertising on as they want. But if you're going to put news on, you can't put adverts on. Conversely, if you want to print news, you don't print adverts. But that's not a CPGP point of view, that's just me. Cheers.